Judge Merchan found that Donald Trump violated the gag order that he issued and is held in contempt on 9 out of the 10 alleged violations. I want to walk you through his decision and the order and what this means. I'm Eliza Orlins, career public defender here in Manhattan for the last 14 years. So after hearing arguments last week and having a hearing with regards to the contempt, this morning Judge Merchan issued a written decision on the motion. He lays out the background first. He says the defendant is charged with 34 counts of falsifying business records in the first degree. These charges arise from allegations that the defendant attempted to conceal an illegal scheme to influence the 2016 presidential election. He directed an attorney to pay $130,000 to adult film actress before the election to prevent her from publicizing a sexual encounter. You all know about this. It's further alleged that the defendant reimbursed the attorney for the payments through a series of checks and caused business records associated with the repayments to be falsified to conceal his criminal conduct. Then he talks about the motion for an order restricting extrajudicial statements by the defendant. The court granted that motion and issued an order. They filed a pre-motion letter seeking clarification or confirmation as it prescribes extrajudicial speech against family members of the court, the DA, and other individuals mentioned. Then the court issued an expanded order on March 26th, and the defendant sought emergency stay, which was denied. This is just the procedural posture. The defendant was served with the signed order to show cause on the same day in court, and then the prosecution moved the court to find the defendant in criminal contempt for willfully violating the expanded order on 3 separate occasions. And then another order to show cause for willfully violating on 7 additional occasions. A hearing was conducted on April 23rd. The prosecution seeks a $1,000 fine for each of the alleged violations. And they are also asking the court to warn the defendant that this conduct will not be tolerated and that incarceration is an option if necessary. The judge includes the order here, basically what it said, which was essentially that he should not make public statements about foreseeable witnesses, about counsel, the DA, members of the court staff, the DA's staff, family members of any of the above, that could be made with the intent to materially interfere with or cause others to materially interfere with the work in this criminal case, or make or directing others to make public statements about any prospective juror. Moving on to the findings of fact, the court considered the respective arguments and the submissions, and these are the 10 posts, 3 of which were reposts, so the judge had to basically rule on whether a repost of material previously posted by another source on another website or social media account which contains the defendant's words, and reposts of material based on another person's account which do not contain commentary by the defendant, whether those things are in fact still a willful violation of the court's order. The judge notes that the defendant does not dispute that he either posted or reposted all 10 of the posts in question. However, he advances several defenses to support his claim that his actions do not constitute a willful violation of the expanded order, and he should not be found to be in criminal contempt. He argues, for example, that reposting another's post does not violate the expanded order because the words are not his own, but those of someone else, that he believed reposting was permissible because the prosecution and the court did not move to enforce the expanded order after the first repost, and that he did not willfully violate because the posts constitute protected political speech made in response to attacks by Michael Cohen and Stormy Daniels. Okay, then the judge moves on to conclusions of law, and he explains that a judge is authorized to hold a party in criminal contempt for willful disobedience of a court's lawful mandate. This is to protect the dignity of the judicial system, to punish the contemptor for disobeying a court order, and it requires a showing of willfulness on that person's part, which must be proven beyond a reasonable doubt, and they must, for the moving party to establish the existence of a lawful order expressing an unequivocal mandate, a violation of that order, and that it is made with knowledge and is willful. And the adjudication occurs at a hearing with due process, including notice, written charges, assistance of counsel, compulsory process, etc. The judge states that he did, in fact, hold that hearing on April 23rd, and then he issues his decision. The court finds that the prosecution has established the elements of criminal contempt beyond a reasonable doubt as to exhibits 2 through 10. This court's expanded order is lawful and unambiguous, and the defendant violated the order by making social media posts about known witnesses pertaining to their participation in this criminal proceeding by making public statements about jurors in this criminal proceeding. The judge needed to decide about these reposts and whether that is something that does reflect the views of the defendant. Well, he says that the defendant curated the posts at issue, took the necessary steps to publish the posts on his Truth Social account and on his campaign website, and that both of those things exclusively represent the opinions and views of the defendant, and neither is an open forum for others to post their content. So in doing so, he endorsed the posts with one purpose in mind: to maximize viewership and communicate his stamp of approval. Indeed, the defendant has boasted about the reach of his Truth Social platform when describing its value. He says it's how he gets the word out. He has 7 million followers. He gets it to spread all over the place. Everybody seems to get whatever I have to say, and quickly. If it didn't work or properly get the word out, I wouldn't use it, but it does work really well. So that is how the judge infers that there can be no doubt whatsoever that the defendant's intent and purpose when reposting is to communicate to his audience that he endorses and adopts the posted statement as his own. So he says it is counterintuitive and indeed absurd to read the expanded order to not prescribe statements that the defendant intentionally selected and published to maximize exposure. This is not to say that a repost will always be deemed a statement of the reposter, as context is directly relevant. However, here, under unique facts and circumstances, the only credible finding is that the reposts constitute statements of the defendant. Then he purports to quote Jesse Waters. This is not a repost, but rather the defendant's own words. Mr. Waters' statement was altered, placed in quotes, attributed to him, and posted, but it called into question the legitimacy of jury selection, and that was a clear violation of the expanded order and requires no further analysis. Then he gets into the arguments contained in the exhibits being made in response to political attacks, and the expanded order does permit the defendant to respond to political attacks, but merely characterizing every one of the defendant's postings as a response to a political attack does not make them so. The defendant did not produce any exhibits at the hearing. He did refer to 2 postings contained in his opposition papers, including a post by Michael Cohen, where he comments on those who support the defendant for the presidency, and another post by Michael Cohen referencing Michael Avenatti's likelihood of receiving a pardon from Donald Trump. The judge calls this a tenuous correlation sufficient to give this court pause as to whether or not the people have met their burden as to this exhibit. However, the same cannot be said with remaining exhibits 2 through 9, which attack the credibility of arguably 2 of the more high-profile witnesses in this case. To allow such attacks upon protected witnesses with blanket assertions that they are all responses to political attacks would be an exception that swallowed the rule. The expanded order does not contain such an exception. At the same time, the court is keenly aware of and protective of the defendant's First Amendment rights, particularly given his candidacy for the office of President of the United States, and they don't want to infringe on legitimate free speech rights, and they want him to fully be able to campaign for the office for which he seeks and be able to respond to and defend himself against political attacks. And that's the reason why the court exercised discretion in crafting the expanded order and delaying issuing it until the eve of trial. The judge states it's narrowly tailored to prevent risk to the fair administration of justice, and clearly unambiguously identifies the limited way in which the defendant's speech is restricted. And the judge has to determine the appropriate punishment now that he has found beyond a reasonable doubt that that Donald Trump did in fact violate the court's order. So finally, lastly, the judge says that he is imposing a $1,000 fine on each of the 9 counts of the violation of the court's order. He could, in fact, impose jail time, but he says it would be preferable if he could impose a fine that was more substantial, but unfortunately he is not able to do so within his discretion. He does say in some instances jail may be necessary punishment. So we will keep following this and see what happens. And please like and follow for more. If you are enjoying this content, please share it. Thanks so much.